Namaskar. Good morning, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officers, officials, listener, learners, the most honorable President Prime Minister Modi ji. I welcome all respected doctors and directors. I welcome all honorable ministers and managers. I welcome honorable advocates, advisors, administrators and advisors. I'm Dr. Kesham USC, heartily cordially welcome. It's really nice time, nice place, nice action today that we are describing our the Indian cultural, spiritual, economical, political, social changes in the form of unity and diversity. AI से जुड़ी कंपनियां मार्केट में हैं। केंद्रीय मंत्री डॉक्टर मनसुख दास मांडविया नई दिल्ली में केरल के नवनिर्वाचित भाजपा पार्षदों की वर्कशॉप को गृह मंत्री अमित शाह करेंगे संबोधित। फाउंडेशन मॉडल्स को इंडिया एआई मिशन से मिल रहा सहयोग, संगठन को मजबूत करना। बांग्लादेश में हो रहे हैं आम चुनाव, 12 करोड़ से अधिक मतदाता डालेंगे वोट। पीएम ने एआई स्टार्टअप्स के फाउंडर्स से की थी मुलाकात। T20 विश्व कप आज नामीबिया से होगा भारत का मुकाबला। भारत का एआई इकोनॉमी दिल्ली के अरुण जेटली स्टेडियम में होगा मुकाबला। इजरायली पीएम नेतन्याहू ने डोनाल्ड ट्रंप से की मुलाकात। Relationship between international law and municipal law. The Chinese practice, in the words of Chinese writer, regardless of what the bourgeoisie is, supremacy of international law over municipal law, supremacy of municipal law over international law, monist theory or dualist theory. All these theories completely reflect the will of the bourgeoisie, and their historical changes are solely determined by class interest. The Chinese authors have never accepted the supremacy of international law over municipal law and have vehemently criticized this view. But as pointed out by Jerome Allen Cohen and Hamza Chiu, the relation of international law to municipal law is not only of basic theoretical importance in the conduct of international activity. Yet Chinese writers rarely discuss this problem, and those who do, like Ying Cao, almost exclusively confine themselves to criticisms of relevant Western theory and practice. These criticisms follow the arguments set forth in the Soviet legal literature, but Soviet authors have in addition attempted to construct their own specific explanation of the relationship between international law and municipal law. Thus, China has yet not articulated a definite theory to explain the relationship between international law and municipal law. Austrian practice in Netherlands and Switzerland. Article 9 of the Austrian law. This has been interpreted to mean the general recognition need not necessarily be universal, and that the changes in these rules are automatically reflected in international law. However, these rules may be overridden by ordinary laws. The same attitude prevails in countries like France as regards the abrogation of treaties, like Switzerland and the US. Austria adheres to the view that laws enacted in violation of prior treaty obligations are internally valid, although they constitute an international tort. However, in case the ordinary rules referred to in Article 145 of the Austrian Constitution, while enacting the Constitutional Court can declare any law violating existing rules of international law is valid, whether embodied in treaties or not. It may also be noted that, unlike in the US, the Constitutional Court of Austria refuses to review the constitutionality of international agreements. Thus, as pointed out by Ignaz Hohenfelder, the Austrian constitution may be described as following a middle course between extrinsic monistic theory of the absolute supremacy of international law over international law and the principles according to which in internal law the will of the people as expressed at any given moment by the majority of the national rate should be supreme. Indian practice before the adoption of Indian Constitution, the Indian practice in respect of relation of international law to internal law was similar to the British practice. After the adoption of the Constitution of India, everything depended upon the provisions of Constitution. In order to know the position of international law in the post-Constitution period, it is necessary to examine the relevant provisions of the Constitution of India. The most relevant provision is concerned in Article 51, which runs as follows. The state shall endeavor to promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations in the dealings of organized people with one another, and is settlement of international disputes by arbitration.